Hello, I'm Doug Muzzio. This is City Talk. On March 10, 2011, lobbyist Richard Lipsky was charged in a 2-count bribery and money laundering complaint by U.S. Attorney Preet Bharara. Lipsky and 7 others, including New York State Senator Carl Kruger, pled not guilty to the charges. But 8 months later, Lipsky pled guilty to some of those charges. He served 90 days in federal prison and spent 2 years on probation, and that ended on February 24th of this year. Today, Richard Lipsky is here to talk about his case, about corruption in Albany, and what he and others see as the corruption of the American criminal justice system itself, specifically the unchecked power of prosecutors and the perversion of the grand jury. Richard, before his arrest, was a lobbyist, a self-styled fighter for the underdog, who, according to the New York Times, quote, was omnipresent in press rooms at City Hall and the state capitol. A wiry man with a gray mustache, bags under his eyes, and a Bluetooth headset that seemed to have been permanently lodged in his ear, endlessly pushing, prodding, and pitching stories. Currently, Richard is working with the National Association of Criminal Defense Lawyers. Joining Richard and me is Gerald Lefcourt, noted criminal and civil defense attorney who represented Richard in his criminal case. In his 40 years practicing law, his clients have included Abby Hoffman, Black Panther Party leaders, real estate mogul Harry Helmsley, actor Russell Crowe, New York State Assembly Speaker Mel Miller, and on and on. Mr. Lefcourt served over 20 years as Speaker of the New York State Assembly's designee to the Commission on Judicial Nomination. He has served as chair of the Criminal Advocacy Committee of the City Bar Association and has been recognized in New York Magazine's survey of outstanding practitioners. Oh, God, I'm just stopping with you. Welcome, Richard. Welcome, Jerry. Okay. You plead guilty in January of 2012. 2 weeks before you were to go on trial on the charges brought by Bharara. And at that point, you said to the judge, I acknowledge that my actions were in violation of the law and I knew they crossed the line. You accepted responsibility for your conduct and talked to your incredibly poor judgment. What were you guilty of? And what were you saying you were guilty of?
Well, Doug, I think the important thing, the way I look at it, I think it's important to try to point out is that it's very difficult sometimes when you're dealing in politics to know where the bright lines are, where is behavior that's acceptable and where isn't. My behavior, I believe, crossed over that line because I wasn't paying attention enough to what I should be doing because I hadn't been somebody who had been close to an elected official. My entire career had been oppositional.
I well remember.
And I told, when I first met Jerry, that horrible period after I had gotten arrested, and I told him, you know, I got out of my comfort zone and I got close to an elected official who really was someone I shouldn't have gotten close to. The way I phrased it was, I willingly boarded a southbound express, but got railroaded at the same time.
Ooh, you were always good with the metaphors. So the original charge has you serving up to, according to the criminal complaint, 20 years in prison, 3 years of supervised release, $250,000 twice the pecuniary gain and loss, and $100 special assessment on one of the counts. And then, well, there's $500,000 in the second one. And then you get 90 days? How do you go from 20 years. And then in some of the pre-sentencing, it looked like the sentencing guidelines was somewhere between 5 and 6. But then you get 90 days. How do you get 90 days?
Well, I think that...
and how does he get it to you? For you. Let's talk to him.
I'll turn it to Jerry after I...
Go ahead.
I think, Doug, the way... If you get from 20 years to 90 days, the essence of that is that they got so much wrong in the initial complaint. The problem is, in the federal system, they can go into a grand jury and they can pile on all kinds of information, much of which could be false, and in my case turned out to be false. And then after 8 months, after I was arrested, they came to a different conclusion. And they came to Jerry, the U.S. attorneys came to Jerry and offered him, on my behalf, a deal, which they said, according to what Jerry told me, is that they said, we don't believe Richard belongs in prison. We want to help try to get him probation.
Go ahead. How do you react to that? Let's just set the scene. They call you, you go talk. What is the story?
Prosecutors in the context of a public corruption case say every act must be corrupt. There must be a deal going on. Why did he do that with him? He must be getting something. This is one of these weird cases where the prosecutors learned, as we got closer to trial, that they had so much wrong that actually Carl Kruger and Richard Lipsky saw eye to eye on big box stores, on collecting cigarette
So
taxes.
the bribery count, you're saying, really held no water.
It really was a different world that they came to understand, but they can never admit that they made terrible mistakes by bringing the charges against Richard that they brought. So they say, let's avoid a trial. Let's you and I sit down and work out something where he doesn't have to do what Carl Kruger was doing, which was 8 years.
Right.
Kruger was sentenced to 8 years.
Right.
And if he's the one who's supposedly bribing him, you'd think he'd be worse.
Well, that's why I'm looking at 20.
But they understood that it really wasn't.
So they actually, at least implicitly or explicitly, they came to the conclusion that, in a sense, they had, in some sense, blown the case in terms of the nature of the charge. Now, just prior to the sentencing, I guess the U.S. Attorney's Office sends a 3-page letter asking for leniency in the sentence before Judge Rakoff. And the statement of the U.S. Attorney was that you had provided significant information that led to investigation and prosecution of numerous other persons. And I'm trying to figure out what I missed with the prosecution of numerous and other persons.
Well, you know what? I'm surprised to hear those words. You know what? I'm surprised to hear those words, because what actually occurred is that Richard became a consultant to the U.S. Attorney to make them understand how politics really works. And, don't look at this as bad, look at this as bad. But there was no specific individuals or cases that grew out of his consultation with the United States Attorney?
So, being the cynic from Brooklyn that I am, what this is a cover by the U.S. Attorney saying, we didn't blow this. No, I mean, Richard really gave us stuff that facilitated the investigation, and it's the cover story. Well, am I off on this?
No, you're not off. If that's what they were trying to convey to the public, it wasn't true. What was true was Richard became a consultant to make them understand the way things work. There is no case that grew out of whatever Richard said to them. He never testified as a witness against anybody.
I was searching. I couldn't find it. I figured I would ask you.
But you know what? It was valuable cooperation, because for them to understand this system better.
Excuse me, it contextualized it.
Yeah.
I mean, and Richard.
I gave him a seminar, basically, in Politics 101.
Excuse me.
I went back to the future, Doug.
Excuse me. In fact, I mean, I was one of the people who wrote a letter on your behalf to the judge describing my professional relation, which was just, an acquaintance. But wise and witty, edge, and really some erudition on there. So I can understand
Richard
that.
always represented the little guys in this system, and that's why he was always on the outside. And finally, he meets a state senator who agrees with him on a lot of the clientele that he has, that there shouldn't be big box stores that destroy all the little guys.
Right.
And so they had a relationship that, quite frankly, he never had with any other politician, and it looked bad.
And excuse me, and it was bad.
Listen, I'm the first
No,
one to
I'm
admit
not.
it.
I know you already pled.
I'll be the first one to admit that, and sometimes you make mistakes, and in this system, mistakes can be criminalized, and that's the problem. The laws are so expansive, and the way in which U.S. attorneys look at the political system with such a jaundiced eye, they can pick and choose who they want to target, and there are enough vague statutes and enough powers that they have.
The grand jury does not need competent evidence, federal grand juries. The Supreme Court has decided they could hear hearsay, they could hear illegally obtained evidence, and nobody ever sees what goes on in a federal grand jury.
Go a little bit more. There's no judge, there's no defense, nobody sees nothing. Just keep going, and then, Richard, talk about where you are when they're actually in the grand jury room.
Well, first of all, we don't know that they're presenting a case.
Right.
And we don't know what kind of case it is. We don't know that it's hearsay. We don't know what the basis is. And the federal judge, the federal prosecutors present to the grand jurors a draft of a indictment that they write.
Right.
And they have agents go in there and testify from hearsay and blah, blah, blah.
Wait a second.
And there it is.
I read the whole thing. I mean, to this non-lawyer, it was a little bit, excuse me, but it's all this stuff, and it looks like, man, this is the real deal.
So what I call the tyranny of small decisions by the Supreme Court, nobody could look behind an indictment.
And
No federal judge has the power to look behind the indictment. If what went on was criminal in the grand jury, if there was a trial that led to the conviction, nobody could ever look back at it. And it's different in states, in many state grand juries. For instance, in New York, he would have had the right to testify. He would have had the right to present evidence that was exculpatory.
Would he have a right to an attorney?
He would have a right to counsel in
Wow.
the grand jury.
And the grand jury itself. Excuse me. This seems to make sense. Why is it at the federal level that you have this massive exclusion and this absolute immunity? What's the historical? I mean, is there a legitimate historical root? No, I thought not.
The ABA, the American Bar Association, the National Association of Criminal Defense Lawyers, many other advocacy groups have been urging Congress to implement basic fairness in the federal grand jury so that people could have the right to present their case. Because once you're indicted in this society, it's over. It never leaves. It never gets off your record.
That's crazy.
Exactly.
I mean, the other day when the Menendez indictment came on, the next day the New York Times comes out and says you got to resign. I mean, did they read the case? I mean, there seems to be far less of a presumption of innocence.
Correct.
And don't get me wrong. I understand that there is sort of this miasmic culture of corruption.
Doug, it's also that
I'm talking too much.
It's the popular view of politics is so jaundiced. People hate politicians. They hate lobbyists. And that was one of the things in my case while we were going towards a possible trial. The thought of going to trial as a lobbyist with all of the stigma that is associated with it, and what prosecutors often do is use your category of who you are to convict you in the eyes of the jury. And that's what they did when Preet Bharara did his press conference. While I was in a holding cell in the federal building, unable to even know what was going on, he was presenting his case. And I think I should point out that one of my co-defendants, the developer, Aaron Molinsky, was actually let off with, I think it was a non-prosecution agreement. And the letter from the U.S. attorney said, after a thorough investigation. So 8 months after the guy was arrested, they did a thorough investigation.
Hey, come on. Justice may be slow, Richard.
But of course, they kicked Malinsky out of the Brooklyn Navy Yard where he had a $30 million project.
Sure.
And his whole career was destroyed by that as well.
Right. Talking about your point about the language in the complaint, the U.S. attorney says, quote, it reflected a broad-based racket reflecting an unholy alliance of politicians, bad word, lobbyists, bad word, and businessmen, for a lot of people, a bad word. So, I mean, and this U.S. attorney, and I presume others as well, if you read their complaints, it's like every sentence is the headline of a media piece. There's a very politically savvy element to this.
This is talking prosecution. When they indict, the indictment is filled with verbiage that is press-worthy. That is the goal.
It's great.
You know, there used to be the notion that you file a charge and, you know, you make it as simple as possible, and there's no big grandiose press conferences.
It's
that
the
really,
celebrity culture. I don't know. Well, also, I think it's, you know, it's political ambition in some sense. There's a lot of things going on.
Obviously, there's political ambition with Preet Bharara. What it is exactly, who knows? Maybe he's going to run for governor.
My phone. Oh, no. See, I shouldn't associate with people like you.
But what's annoying is what it does to the atmosphere in trying to get a trial. I mean, in political corruption or public corruption, it is so, trying to select a jury, you should hear what jurors say. I mean, they are just mortified by politics because all they hear is this kind of stuff from prosecutors.
Right, sure. And news media. I mean, it's an echo. Yeah. It's certainly an echo.
The other piece, and gets to what about your point about prosecutors. People look at prosecutors as if they have been beamed in from some other planet to be these white knights, these avenging angels, not understanding that they are politicians, that they are political appointees, that they are part and parcel of the overall government that the people have such disdain for. But the law...
My governor, as a matter of fact.
Well, the law and order ethos, you know, that, and I say law and order, you know, from the television show Law and Order, Sam Waterston is the great example of, you know, the prosecutor is only interested in the pursuit of justice, and most people are socialized to that concept.
Oh, the media is very powerful in projecting.
And yet the examples of not only mistakes, and maybe in my case overreach, but egregious errors of withholding evidence and things like that.
Yeah, all you have to do is think of a case like the Republican senator from Ted Stevens.
Oh, it's awful.
I mean, you know, here's a guy who, trying to get reelected, demanded a speedy trial. And
they bring the indictments just before the election.
Yeah. And he had some great lawyers in Washington, and they found all this evidence that was withheld. And it led to one of the most incredible investigations of the Justice Department.
It was. I read that 583 investigative report that went to, I guess, Judge Sullivan.
Yeah.
And
one of the prosecutors committed suicide.
But nobody else. See, what the thing is, nobody pays.
Yeah.
You read about the Ted Stevens case. You read Sidney Powell's book, License to Lie, about the Enron task force, and it goes on and on. It was very enlightening, you know, inviting you folks and then reading this stuff. But I have to tell you, you know, my skepticism is really approaching that cynicism line. Talk about strategy a bit, though. You're sitting there, and I presume you think you can beat it. I don't know. I'm just making assumptions. What's the kind of strategy, both the conceptual strategy and I guess the game playing with jurors that you play? Because it's risky. Because even though if you're 90% sure, 20 years versus 10%, go ahead.
We had an answer for everything. The facts were really good for Richard. But it was this overlay of what does the atmosphere do to him? And he's a lobbyist. So we actually went before a mock jury to try to test how people would react.
How do you do that? You select?
Yeah, we select from this cross-section of the community that would be his jurors.
Right.
We bring them in on a Saturday afternoon.
Do you voir dire them? I mean, do you?
They fill out questionnaires about everything they do, and their background, their employment, their education, and we figure out what kind of jurors are very, very hostile. In other words, you're trying
Who's in the room watching this? Or looking through a glass, whatever, however you do
we
it.
videotape. We have one presenter to present both the government and the defense.
Oh, okay. So the personalities don't influence.
So there's
It's
no presenter bias.
Okay, that makes sense.
And so then they sit and they discuss it. And what do they discuss? How do they discuss it? What things ring true to them? What things upset them?
Okay, in your experience, this works. In a sense, it gives you at least parameters. But do you ever hit it dead on, where the mock jury just gets it, or you blow it and but you don't make a decision just on that?
No.
But have you ever had sort of a perverse one of these juries that you based some of your decision on?
I actually had one that went the other way.
It's even better. That's better.
So I kept on arguing this case. It was actually an oil company that provided oil to every New York City building. And the price that they charged was based on going to a publication and getting the average of various oil companies. And they all posted their prices. And so this oil company posted the highest price because they wanted to drive up the price.
Right.
So, but there was nothing wrong with it. There was nothing illegal about it. They were indicted.
Like rational economic.
They were indicted for fraud. And so how it was argued to the jury, instead of saying they had a right to do it, the jurors were much more happy hearing that there was nothing that prevented them from doing it. It's the way you characterize something.
Oh, interesting. Rather than positive, it's an absence of a negative.
Yes, and that they were not on notice of doing that. This would be wrong.
Right.
So you learn how they think and how to pitch ideas, and there's nothing better than to hear lay people talking about the facts of your case rather than.
I would see. I've been on both criminal juries and on civil cases, both in Queens and I find them absolutely fascinating. Well, and I think they do.
One thing
people should volunteer for juries.
Yes, yes.
One thing I saw, I mean, in the mock jury, I believe that there were two of them that convicted me and two of them acquitted me. So it's like a flip of a coin.
So you have this data. What do you do? So you've got a choice. Either I plead the 3 months, or substantially reduced, or I go to trial and.
Well. I think the choice was decided for us more or less. At least what I remember from when the mock juries split 50-50, let's say.
Right.
And you don't know.
No.
And what I saw in the mock juries was how one personality can basically
I've seen that
take over
Yep.
So you can have a really good defense personality or the opposite.
Yep.
And wow, that's a heck of a risk to take. But I think the risk and everything was taken out when the U.S. attorney came to Jerry, and I think you said, "How do you see my client? Don't you take it from there?" It's and at that point, they don't want me to go to prison. They want me to try to get probation.
They realized that they had overcharged this person.
I broke down. The prosecutor McCourty talks personally about your remorse and how he really believes that you were sincere and not making a deal. I mean, I read it and I said, man, these guys are covering,
Well, but of course they're never wrong.
Right.
But just to say, let's work it out.
Yes, yes. Is that very unusual in your practice?
Yes. Well,
and you've had some characters.
Yes, in the feds, they're very, let's go, always, we're right, you're wrong.
Okay, so we've talked about prosecutors and the almost inherent ability to misconduct, and we've talked about grand juries. if you were to establish reforms on a national level, because we'll talk about the federal, what specific things would you recommend / impose?
One of the things you have to do is to immediately require prosecutors to fully disclose the evidence in their case. They're always hiding the ball, trying to withhold, key stuff so that there's surprise at trial. If there was fair discovery and prosecutors were required to disclose all the negative stuff about a witness, for instance, like in the Stevens case, stuff that they withheld, the defense would be prepared to meet. Often defense lawyers go into trials wondering, what is this witness going to say? How do I deal with it? What is the impeachment material? What material exists to make this person not believable?
More. What else?
Well, it's also that I think, and I've become kind of an expert on this.
Well, a lot of you,
unfortunately,
criminals, become experts on this system.
The issue is of materiality. So it's up to the prosecutors to decide what is material, right? And they withhold stuff they don't think is material. But how do they know when they don't know what the defense case is and they don't know so much?
So we're saying one thing is the discovery process. Another thing is the charging process. The grand jury is a captive of the federal prosecutors. There are no rights for a defendant.
There's no judge. There's no defense attorney.
Anything.
You're not even there.
Exactly.
They don't have to. I found this absolutely mind-blowing.
So in the charging decision, which could be the end of it, once you're charged in our society and it's a public matter, it never goes away. It's never off the internet. You could be found innocent and it doesn't matter. It's always there. So the charging system, the discovery system, the quality of defense lawyers really has to be upgraded, and people have to understand how important it is to have a fair adversary system so that people don't get wrongly convicted. The New York Times yesterday pointed out 152 people who are on death row who were exonerated. How is that possible?
Please.
In America. I mean, this is scary. They would be killed. If not for DNA, if not for, really, that's science.
And some of this because of prosecutorial misconduct. They're yelling at me since we're already way over. My special thanks to Richard Lipsky and Gerald Lefcourt for being on the show. Join me here on CUNY TV. Hello, I'm Doug Muzzio. Let us know what you think about this show. You can reach us at CUNY.TV. When you get there, click on the bar that says Contact Us and send your email. Whatever it is. Thanks, no thanks, obnoxious, do it. Send it.